Hello everyone, welcome to this webinar. First of all, let's do a little voice check. If you can hear me, you can type yes in the comment section. Okay. Am I audible to you? Okay, looks like I'm audible. Hello, I'm Chandrika Bose, Project Manager at Rostrum Legal. And as you know, today we all have gathered here to attend this webinar on contract law. Speaker for today is Advocate Janani Shivamani. She has completed her graduation from Amity University, Noida, and after that, she has completed her post-graduation from Hidayatullah National Law University, Raipur. And after that, she has also spent years in the field of litigation. And today she is here with us. Welcome, ma'am. Now, currently she is working with us at Rostrum Legal. And ma'am, if you have any instructions for our live audience, you can share it, or else we'll just start.
We can start, I believe, because they have to connect with me for a better communication, and I don't think that anything is required here. Okay, we can directly the subject.
Over to you, ma'am.
All right. Very warm good evening, good afternoon. What should I say? All right. A very warm good afternoon to all the boys and girls out here. You have specially gathered here for this topic, which happens to be a very interesting one. So, without wasting any time, I want to quickly go to the topic, as contract happens to be one of the most interesting subjects of my LLB, LLM times, because my specialization is also from there. And somehow I believe why we connect so well to the subject is this is something which relates to our daily happening. Contract is one such thing which is regularly happening all around. We are going to some place, we keep buying some things, and especially the girls who happen to be very shopaholics, so you end up into a lot of contracts on a everyday basis, isn't it? So I would like to start to have your concentration to a presentation as well, so that when I make a point, you get connected to some visuals also. But I would like if you listen more to me, because I believe that the communication of a topic should be in such a way that you should be receptive at the end, right? If I have imparted you something, at the end, you should come up to tell me that what you have learned in a half an hour or a 40-minute session, right? So be prepared, because I'm going to ask you questions at the end. All right. So let's go for that. So here we are. Doctrine of frustration. Just a second. Ma'am Chandrika.
Yes,
I would like to have a small help from you.
Ma'am, you need to share your slide.
Yeah, absolutely. That's what I'm trying to do. Okay. Meanwhile, the slides are getting shared. I would like to interestingly ask you certain questions. I don't know why this issue is coming up. Just a second. All right. What do you understand by what do you understand by doctrine of frustration? Straight away, I would like to come here to that point. What do you understand by frustration? If any one of you understand what is frustration, please tell me in the comment box. Meanwhile, I'm sharing it. There is some technical flaw out here. Just a second.
Ma'am, can you just refresh your page and then try it again? Like I think that should work fine.
I think so, sir. There.
Guys, please be online. We're just getting the PPT live. It won't take more than a minute.
All right, guys. So we are here, and there I start our topic for the day: doctrine of frustration. Right. So, what do you understand by doctrine of frustration? I had asked you. I don't know how many of you have got back with this topic, but without taking much of time, let's go directly. See, frustration is a word which has been coined from a Latin word frustatio. That means what? That means deceiving, deception, disappointment, or to frustrate. Now, you would ask, ma'am, what do you explained here? Frustration is basically something which has already frustrated a particular thing. For example, it has already stopped an act which was going on, has come to an end, because of some event, some kind of thing which has occurred abruptly. All right. So deceiving of a thing is what frustrating a contract or any kind of action. Let me come further with a proper definition so that you will have a better understanding to this topic. In Black's Law Dictionary, it was defined in terms of contract in the following manner: the doctrine that if a party's principal purpose is substantially frustrated by unanticipated changed circumstances, that party's duties are discharged and the contract is considered terminated. Now, what do we understand here? That if two of the parties are having some kind of purpose which forms the basis of a contract, all right, there is something which we had decided. See, I'm going to give you something on so and so date, and on that particular so and so date, I fall sick or I am unable to perform that particular part of act. Then what has happened? I have already frustrated the contract. All right. This is what Black's Law Dictionary has also tried to tell. Now, moving further, this doctrine has been coined in the Indian Contract Act 1872 under section 56. Now, what does it try to tell us? It tries to tell us that this doctrine of frustration has a supervening impossibility. Let me come point by point so that I can be dealing in detail. The doctrine comes within the purview of section 56 of the Contract Act, as it discharges the contract by reason of supervening impossibility or illegality of the act agreed to be done. The doctrine is also known as doctrine of supervening impossibility. See, simply if we have to understand anything which was fixed for a particular purpose, for a particular object, and at the end of it, that has not happened, that has stopped, that has, some event has occurred that it became impossible. So, what has landed up? We have landed up into the category, we have invoked the doctrine of frustration, right? This doctrine of frustration in India has been taken up in the form of doctrine of supervening impossibility. All right, let's go quickly to the doctrine of frustration. I would first like to have you here in the Bare Act thing. I don't know how many of you are having Bare Act. If you don't have, it's okay. Please have a view of the section in the slide. Section 56 deals with doctrine of frustration. Now, doctrine of frustration here talks about two things majorly, and it has been enlisted to have three things altogether. First two things, what it says, it talks about initial impossibility and it talks about subsequent or supervening impossibility. All right. Now, what do you mean by initial impossibility? The first para of section 56 talks about what do you mean by initial impossibility. It says agreement to do impossible act. Now, what do you mean by agreement to do impossible act? Let's quickly go. An agreement to do an act impossible in itself is void. What do you mean by here? Here, I would like to go with certain examples for explaining it in detail. For example, you have contracted with someone, you have made an agreement with someone to say certain things, to do an act which is very much impossible in its nature. Now, what do you mean by that? Coming up, like you have said, A says that I will bring this particular thing by a trick of magic to B. And he says, you pay me in consideration, you pay me something. So if someone says that I will bring something by a trick of magic, by doing something, do you really think that that can happen? No. If, say, let's take another example. If Shyam says, see, you give me 10,000 rupees if I bring Raghav, who is already dead, to life. Okay. So this is the second example which he states. Here, can you bring a dead person in life? No. This is another area where the contract has itself, landed up into frustration. You cannot have contracts in that way which promises to do an impossible act. Already आपने एक चीज ऐसी कही है जो हो ही नहीं सकती है in reality. Right? So this is what para 1 says. Simply कि एक agreement अगर आप ऐसा करते हैं जिसमें कोई भी subject matter which is not relevant, which cannot come into reality, and you post that and you make an agreement on that basis, that means you have done an act for impossible, which is impossible in itself, and that type of agreement happens to be void in nature. Secondly, going to the second part of section 56, which states contract to do acts afterwards becoming impossible or unlawful. Now, what do you mean by contract to do acts afterwards becoming impossible or unlawful? Here, we have, okay, now this second portion, second part of the contract basically talks about the supervening event. All right. What do you mean by supervening event? That means a contract was made. It was very much valid. But subsequently, the act has now become either impossible or it has become illegal in nature. So, for example, if I have to quote you by example, right? So here, if suppose A and B entered into a contract, all right, to do certain shipment thing, and subsequently A was from, say, suppose India, and B was from some another country. Thereafter, with the time, there was a war declared between both of these countries. As soon as the war was declared between both of the countries, now the contract in between them cannot be performed because the role of the governmental interference is there. Both the countries are not allowed to have any trade relationships thereafter. So this has rendered the contract as now what? It has become voidable in nature or void in nature? It has become void. If the parties want to subsist the contract, then it becomes voidable. Otherwise, the frustration has been invoked out here, right? The supervening event has been occurred. What is the supervening event? That there was no control of the parties in this particular thing. The war has been invoked and the contract has been subsequently void in nature. Moving further, the third para of this particular section 56 talks about compensation. Now, what is compensation? Compensation for the loss through non-performance of act known to be impossible or unlawful, where one person has promised to do something which he knew or with reasonable diligence might have known which the promisee did not know to be impossible or unlawful, such promiser must make compensation to such promisee for any loss which such promisee sustains through the non-performance of the promise. Now, coming here, I would like to know, I would like that you people should know another area, which is the compensation clause of section 56. What para 3 of section 56 talks here? It says that some act or event has happened already. Okay. Now, this particular act has rendered the contract as the contract has been frustrated. Now, when the contract has been frustrated, what has subsequently happened? It has invoked either of the party for the non-performance of the contract to demand for compensation for the wrong of the another. Now, section 56 specifically, this is the very, very important area of section 56, which talks about the compensation area, right? So, section 56 talks about the this compensation area of sorry, I'll just come back again. I would like to go with an example out here. Say, suppose A says that I'll marry B, right? Knowing that A is already married to C. Now, can A marry B? Because he's already married to C, legally he has been not allowed to do this. So, if he commits still this, he will be committing the offense of polygamy. The offense of polygamy. So, when A cannot marry B, but he has already promised that I'll marry, and B has subsequently made all the arrangements to get from the booking of the hall, by doing so many other things. He has mentally suffered the emotional and all the other connects that has made this person suffer. So what will happen now? Here, B will be rightly compensated by A for all those loss which has been occurred, right? So this is what the compensation term in para 3 is referring to, right? Now, moving ahead with the, I think you have understood what section 56 says here. Section 56 basically is talking about three things. Let us sum up very quickly, and I'll go with the bilingual thing while seeing. What is that? सबसे पहले वो ये बोलता है कि भाई अगर आप ऐसा एग्रीमेंट कर रहे हैं जो एक इम्पॉसिबल एक्ट करने की बात करता है, तो वो तो भाई वहीं पे गलत है. आप किसी को जादू से थोड़ी ला सकते हैं, आप किसी मरे हुए इंसान को थोड़ी जगा सकते हैं, नहीं कर सकते हैं. अगर आप ऐसे किसी पर्टिकुलर एक्ट के लिए कोई अग्रीमेंट करते हैं, तो वो अग्रीमेंट इन इटसेल्फ फ्रॉम द वेरी बिगिनिंग ऑफ इट void ab initio होगा, वो कॉन्ट्रैक्ट void इन नेचर होगा. अब सेकेंड में हम ये समझते हैं कि where there has been an agreement and that agreement says that see, यहाँ पे हमने agreement किया कि भाई A is going to sell something to B और something to B. Subsequently, जैसे मैंने वॉर का एग्जाम्पल दिया था, दोनों ही A और B की कंट्री के बीच में वॉर आ जाता है. तो जब वॉर आ गया, व्हाट हैज हैपेंड? द वेरी ट्रांजैक्शन, जो ट्रांजैक्शंस होने चाहिए थे, अब वो पॉसिबल नहीं हो सकते. कम से कम या तो कुछ ड्यूरेशन ऑफ टाइम के लिए, जब तक ये वॉर सबसिस्टिंग है, या फिर इट विल बी सस्पेंडेड. इट कैन बी सस्पेंडेड फॉर एवर एट द ऑप्शन ऑफ द पार्टी. अगर ए ने बी के साथ वो किया, तो वो सबसिस्टिंगली उसे खत्म कर सकता है. ये हुआ हमारा सेकंड क्लॉज विच टॉक्स अबाउट द सुपरवीनिंग इवेंट. यहाँ पे वो एक इवेंट की बात कर रहा है और कह रहा है कि भाई कुछ ऐसा हो गया है, कुछ एक इम्पॉसिबिलिटी आ गई है जिसकी वजह से ऐसा हो गया है. अब इसमें एक और एग्जाम्पल अगर मैं देना चाहूँ, जो बेयर एक्ट में भी दिया हुआ है. ए ने बी से शादी करने का वादा किया, ठीक है. अब भी शादी करने के पहले ही 2 दिन पहले, 1 हफ्ते पहले पागल हो गया. पागल हो जाने के बाद क्या आपको लगता है कि ए बी से शादी करेगा? He will not do, because a reasonable person will abstain himself from doing this contract. अगर ऐसा होता है, then this has happened because of what reason, what purpose? This has happened because of a supervening event, a event which has occurred and it is beyond the control of that party. इस वजह से ये पर्टिकुलर कॉन्ट्रैक्ट अब सबसिस्टिंग नहीं हो सकता. Third, when we go with the third point, which talks about the compensation. Compensation में क्या बोला था मैंने कि compensation section 56 का बहुत ही lucrative area है, बहुत ही interesting area है, क्योंकि section 56 की बात एक और section भी करता है contract में, जो हम आगे देखेंगे. Right? So where we talk about section 56, compensation की बात कहाँ कही थी कि भाई A ने B से शादी का वादा तो किया था और B वहां पर शादी करना चाहता भी था, लेकिन A को पता चला, A तो पहले से ही शादीशुदा था C से, तो जब B को ये बात पता चली तो ये कॉन्ट्रैक्ट नहीं हो सकता है, बिकॉज ये बहुत ही इलीगल इन नेचर है. देन जो बी ने जितने भी खर्चे किए, उसके इमोशनल लॉस थे, जो भी लॉसेस है, उन सारे लॉसेस को कॉम्पनसेट कौन करेगा? ए करेगा. और यही सेक्शन 3 मैंने पैरा 3 के सेक्शन 56 में कहा भी गया है. लेट्स मूव ऑन फर्दर. इट सेज राइट, आई वुड लाइक टू गो विद द अनदर पॉइंट. नाउ यहां पर मैंने आपको 2-3 एग्जांपल्स जब दिए, यहां पर मैंने आपको ये नहीं बताया कि कहां पर हमारी फिजिकल इम्पॉसिबिलिटी थी और कहां पे हमारी लीगल इम्पॉसिबिलिटी थी. द नेक्स्ट पॉइंट रेफर्स टू दैट ओनली. द इम्पॉसिबिलिटी हियर not only means the physical impossibility, but it also means the legal impossibility. अब इसका मतलब क्या हुआ? फिजिकल इम्पॉसिबिलिटी तो भाई मैं चाहती थी कि मैं राइट, लेट्स गो विद एन एग्जांपल. मैंने आपको कहा कि चलिए मैं बहुत अच्छा गाती हूँ एंड लेट्स डू अ कॉन्ट्रैक्ट. ठीक है, आई विल परफॉर्म. आपने भी इंटरेस्ट दिखाया, आपने कहा कि मैम आप मेरे कॉन्सर्ट हॉल्स में 4 दिन का शो कर लीजिए और उसके लिए वी विल हैव व्हाटएवर. वी एंडेड अप इन अ लीगल कॉन्ट्रैक्ट. आई सेड ओके, वेरी वेल, हाँ मैं गाने के लिए आपके कॉन्सर्ट हॉल में तैयार हूँ. बट कॉन्सर्ट हॉल में जब मुझे गाना था 4 दिन, उसके जस्ट 2 दिन पहले मेरी बहुत तबीयत खराब हो गई. आई वॉज हॉस्पिटलाइज्ड एंड मैं इस कंडीशन में चली गई कि मैं वो आपका काम कर ही नहीं पाई. देन व्हाट हैज हैपेंड? आई हैव लैंडेड अप इनटू द physical impossibility. What has happened physically? See, the things have gone beyond the control and now I cannot perform because I am already ill, right? So this area, section 56, when it is talking, it talks about 2 types of impossibilities. One is physical impossibility and another one is the legal impossibility. जो एग्जाम्पल मैंने आपको legal impossibility का ऑलरेडी दिया है. ए बी के साथ जाना चाहता था कॉन्ट्रैक्ट में, कुछ शिपमेंट मंगाना चाहता था, लेकिन meanwhile there was a war which was declared between both of the countries. When both of the countries landed up into a war, what has happened? Here legally the transactions couldn't be possible. So the impossibility of a contract here talks about 2 things. One is physical impossibility and another one is legal impossibility, right? All right, I think you have understood till here. Let's go further. Before the doctrine of frustration, अब यहाँ पे हम क्या बात कर रहे थे कि भाई फ्रस्ट्रेट करना क्या होता है. जब डॉक्ट्रिन ऑफ फ्रस्ट्रेशन वाज इन प्रैक्टिस, what used to happen? डॉक्ट्रिन ऑफ फ्रस्ट्रेशन में ये होता है कि भाई आपने इन्वोक किया, कुछ आपका कॉन्ट्रैक्ट फ्रस्ट्रेट हो गया बिकॉज ऑफ आइदर ऑफ द 3 रीजंस. जब ऐसे फ्रस्ट्रेट हो गया तो आपका जो कॉन्ट्रैक्ट है वो टर्मिनेट हो जाता है, खत्म हो जाता है, यहाँ पे रिसेंड हो गया. लेकिन the doctrine of implied term which was there in practice, that was in praxis. What I mean from here, जब doctrine of frustration का concept नहीं आया था, this doctrine of frustration का concept had come from England, and till the time this concept was not there, whatever was mentioned in the contract, whatever terms and conditions were there in the contract, that used to be followed as it is. जो कुछ भी कॉन्ट्रैक्ट के टर्म्स एंड कंडीशंस में था वो एज इट इज फॉलो किया जाता था। उस समय कोई ऑप्शंस नहीं थे। आप ये नहीं बोल सकते कि भाई फ्रस्ट्रेट हो गया कॉन्ट्रैक्ट, कोई ऐसा इवेंट हो गया जिसकी वजह से हमारा कॉन्ट्रैक्ट परफॉर्म ही नहीं किया जा सकता। These type of excuses were not there before the doctrine of frustration had come into being. Right. The next point here is the law regarding contractual obligation was extremely rigid. That's what I said. Whatever was there in the contract, you have to follow straight away. कुछ नहीं कर सकते। अगर आपने बोला है कि आप ये शिपमेंट भेजेंगे तो आपको भेजना ही है। आप ये एस्केप ले ही नहीं सकते कि कोई और कुछ इवेंट हो गया है जिसमें फोर्स ही नहीं कर सकता था, जिसे मैं जानता नहीं था, and this has happened. That doesn't happen here. All right. So supervening unforeseen events owing to which the performance has become impossible or more wondrous were not regarded as an excuse of non-performance. That's what we already discussed कि non-performance का clause आप इस तरीके से नहीं बोल सकते कि भाई कुछ event हो गया है, कोई ऐसी चीजें घटी हैं जिसको मैं सोच ही नहीं सकता था और हो गया, and now the contract has become impossible. ये चीजें पहले नहीं हुआ करती थी. You have to honor the contract by whatever means you can. All right. This I have already covered. Here I wanted to bring what is initial impossibility, what is the supervening impossibility. The first para, as I said, talks about the initial impossibility. Para 2 talks about the supervening or subsequent impossibility. And para 3 here talks about the non-performance of the act which has become impossible or unlawful. And for that purpose, you have to compensate the other person. Now, when we discuss the doctrine of frustration in the contract, you cannot go without reading these landmark judgments because they have formed the very basis of this doctrine. So, the first case, which is the Paradigm versus Jane's case, in this case, in 1647, this case had come. What had happened? That Paradigm एंड जेन में सिंपली पैराडाइम जो था उसने वो यहाँ का टेनेंट था, एक लैंड में वो टेनेंट था, जेन ओनर था। अब बात यहाँ आई कि भैया मैं आपको टेनेंट हूं तो मैं तो आपको डेफिनेटली रेंट पे करूंगी। जब मैंने आपको रेंट पे कर रही थी, जब मैंने आपको रेंट पे किया, एक पर्टिकुलर पीरियड के लिए आपने मुझे एक पर्टिकुलर लैंड जो है वो रेंट में दिया। उसमें मुझे 2 महीने के लिए सम रैंडम एलियन एनिमी मुझे बाहर निकाल दिया गया। आई वॉज डिस्पोसेस्ड ऑफ दैट पर्टिकुलर लैंड। व्हेन आई वॉज डिस्पोसेस्ड ऑफ दैट पर्टिकुलर लैंड, आई वॉन्टेड टू कम बैक टू दैट। मैंने ये बोला कि भाई मैंने वो 2 महीने के रेंट आपको देने से मना कर दिए। मैंने कहा भाई मैं तो उस 2 महीने थी ही नहीं लैंड पे, तो मैं क्यों आपको वो रेंट पे करूं। I took this particular as in I alleged for this thing कि भाई मैं क्यों करूं, मैं तो ये ग्राउंड ले रही हूँ कि भाई 2 महीने के लिए मुझे निकाल दिया गया था और I will not pay the rent for it. But what court held in this case was, court said you were dispossessed for 2 months by some enemy. That is none of his business. That was none of the business of the Jain. भाई लैंडलॉर्ड ने आपको लीज पे एक पर्टिकुलर लैंड दिया है, उसमें आप थे आप नहीं थे, आपको निकाल दिया गया था, वो आपका प्राइवेट अफेयर है, वो आपका प्राइवेट बिजनेस है। नोबडी कैन से, आप ये नहीं बोल सकते कि वो लैंड का मेरे पास राइट तो था लेकिन भाई मैं डिस्पोसेस था तो वो 2 महीने का मैं रेंट नहीं दूंगा। Court held that you have to pay the rent for those 2 months also. This happened to be the first case in the chain of this doctrine of frustration. The other case, which is regarded as the landmark, as the genesis, origin of this particular doctrine of frustration, is Taylor versus Cadwell. Now, what had happened in Taylor versus Cadwell? This case came in 1963 and इस केस में ये हुआ था जो मैं आपको इन अ वे बता चुकी हूँ। यहाँ पर 2 पार्टीज के बीच में एक कॉन्ट्रैक्ट हुआ था कि वो 4 दिन के लिए डिफेंडेंट से 4 दिन के लिए उनके कॉन्सर्ट हॉल में वो परफॉर्म करेंगे। वो वहां पर अपने म्यूजिक शोज देने वाले थे। उनका जो हॉल था, वो म्यूजिक कंसर्ट हॉल जो था, वो 4 दिन की बुकिंग के लिए गया था। अब इस बात को सोच के क्या किया गया, सबको बता दिया गया, पैम्फलेट्स बिठवा दिए गए कि भाई इनका परफॉर्मेंस है इस जगह पर, ऐसे कह के हर जगह पे एक सेलिब्रिटी का परफॉर्मेंस था वहां पे, तो ये सबको बता दिया गया। बट एंड ऑफ द डे में व्हाट हैड हैपेंड कि जिस दिन वो कॉन्सर्ट होना था उसके जस्ट एक दिन पहले वो म्यूजिक कॉन्सर्ट हॉल जो है वो जल गया, दैट वाज सेट ऑन फायर, बट बाय व्हाट रीजंस नोबडी वाज नोन। एंड वो जलने की वजह से व्हाट हैड हैपेंड कि अब तो भाई क्या हो गया, यहाँ पे तो इवेंट हो ही नहीं सकता। और क्यों नहीं हो सकता, बिकॉज जो कॉन्ट्रैक्ट का सब्जेक्ट मैटर था, माने मैं को परफॉर्म करना था म्यूजिक हॉल पे, और वो आपका म्यूजिक कंसर्ट हॉल था, और आपके म्यूजिक कंसर्ट हॉल में आग लग गई, पर हमें नहीं पता व्हाट वाज द रीजन ऑफ दैट पर्टिकुलर फायर। सो दिस मेड द कॉन्ट्रैक्ट टू फ्रस्ट्रेट एंड द इवेंट वेरी मच बिकेम इम्पॉसिबल इन नेचर। यहाँ पे कोर्ट ने भी यही हेल्प किया कि देखिए, ना ही प्लेंटिफ नॉर द डिफेंडेंट was made responsible to pay or compensate either of the one. Why? Because ना ही ये plaintiff की गलती से हुआ और ना ही ये defendant की गलती से हुआ. Whatever promises were exchanged between these two parties and whatever promises were made to the other parties out here have landed up into a frustrated state, and that cannot be made as good. Right? Now the third case, जिससे इंडिया में इस पर्टिकुलर लॉ को यू हैव ब्रॉट इनटू इंडिया, दैट पर्टिकुलर केस वाज सत्यव्रता घोष वर्सेस मुंगनीराम बंगूर एंड कंपनी. In this case, what had happened that Satyavrata Ghosh had purchased a land. All right, उसने एक लैंड लिया था, यहाँ एक लैंड था, ये भी लैंड का ही केस है, यहाँ एक लैंड था, सत्यव्रता घोष ने एक लैंड खरीदा था. मुंगनीराम बंगूर कंपनी जो थी वो बेसिकली एक बिल्डिंग डेवलपमेंट कंपनी थी. Now what they had said that this building development company promised that you buy this particular share of land and we will develop the drainage system and the roads of this particular land for dwelling up into a residential area. हम इसे residential area बना के देंगे आपको, इतना कर देंगे कि भाई ड्रेनेज सिस्टम और रोड सब बेसिक नेसेसिटी वाली चीजें आपको वहां मिल जाएंगी, एंड देयर आफ्टर द बिल्डिंग्स विल बी डेवलप्ड देयर. ऑल राइट, ये जब बात हुई तो इसमें ये प्रॉब्लम आई दैट अ पोर्शन ऑफ दैट पर्टिकुलर लैंड was taken by the government. There was a government interference and government said, see, we want this share of land which happens to be 1/3 or 2/3 of the land and we want this for our military purposes. तो जब ये military purposes के लिए ले लिया, ये लेने के बाद क्या हुआ, अब मुंगनीराम जो कंपनी थी उन्होंने कहा कि भाई हम फिर लैंड को डेवलप क्या करें, ये तो आधा ही लैंड बचा, इसमें तो हमारा डेवलपमेंट पॉसिबल ही नहीं है, अब आधे के लिए हम रोड्स बनाए, ड्रेनेज सिस्टम बनाए, दिस इज नॉट गोइंग टू हैपन. सो दे सेड नो, वी विल नॉट गो विद the development of that particular land. It's better you take your earnest money which was paid. ठीक है, सत्यव्रता घोष ने यहाँ एक अमाउंट दिया, 101 रुपए का अर्नेस्ट मनी दिया कि भाई ये मेरा आपको एडवांस है, और सब्सिक्वेंटली जब आप पूरा डेवलप करके दे दोगे तब मैं आपको बैलेंस ऑफ द पेमेंट पे करूंगा, which didn't happen actually. Why? Because a portion of the land was taken by the government. So यहाँ पे जब गवर्नमेंट ने वो लैंड ले लिया, उसके बाद यहाँ पर वो सुप्रीम कोर्ट ने अब इस केस में क्या बोला, लेट्स गो डायरेक्टली ऑन टू दैट. सुप्रीम कोर्ट ने ये बोला कि लिसन, government has taken that land for the military purposes for a temporary time, for a temporary period. They have not taken forever. It is just for a temporary time that this land is going to be with us. उसके बाद तो वो आपको वापस कर देंगे. सो यहाँ पे क्योंकि कॉन्ट्रैक्ट में ये बात नहीं कही गई थी कि कितने दिन के लिए वो कॉन्ट्रैक्ट में, कितने दिन में वो डिफेंडेंट जो है वो कितने दिन में रोड्स बनाएंगे, ड्रेनेज बनाएंगे, ड्वेलिंग सिस्टम को पूरा क्रिएट करके देंगे, इस बारे में कॉन्ट्रैक्ट वाज एब्सोल्युटली साइलेंट एंड देयर वाज नो वर्बेटम टुवर्ड्स दैट पर्टिकुलर फैक्ट. So the contract here was said that no, the doctrine of frustration has not been invoked out here. यहाँ कुछ frustration हुआ ही नहीं है. This is mere a delay, or you can say the other factors have influenced for the delay in time. But यहाँ पे क्योंकि contract ही इस delay की बात नहीं करता है, तो हम इसे frustration नहीं मानते हैं. Right? Moving on to the next. That talks about the grounds of frustration. And what do you mean by grounds of frustration? Grounds of frustration or doctrine of frustration का जो section है, इसी से सारे most of the questions बनते हैं. Further, grounds of frustration की जब हम बात करते हैं, there are certain 5 of the frustrations के ground which have been enlisted. The first one being destruction of the subject matter of the contract. Now, just now I informed you that Taylor versus Cadwell is the very genesis, very basis of the concept which had brought the doctrine of frustration into being. Destruction of the subject matter से आपका क्या मतलब है भाई? Concert hall में ही होना था, गाना वही गाने वाले थे, but what had happened that subsequently it was on fire. Once the fire was caused, अगर ये किसी पार्टी की गलती से होता, then yes they were liable. बट यहाँ तो ऐसा हुआ ही नहीं. दोनों पार्टीज वर अननोन कि भैया फायर क्यों हुआ और क्यों आग लग गई, क्यों म्यूजिक कंसर्ट इतना डिस्ट्रॉय हो गया कि द वेरी सब्जेक्ट मैटर व्हिच वाज म्यूजिक कंसर्ट हॉल हियर गॉट डिस्ट्रॉयड इन कंप्लीटनेस. राइट? दिस इज द फर्स्ट ग्राउंड ऑफ फ्रस्ट्रेशन. व्हाट डू यू मीन बाय द सेकंड ग्राउंड ऑफ फ्रस्ट्रेशन व्हिच सेज चेंज ऑफ सर्कमस्टेंसेस? नाउ चेंज ऑफ सर्कमस्टेंसेस का बहुत ही बेहतरीन केस है ये क्रेल वर्सेस Henry. What had happened that in Krell versus Henry, the defendant had taken a particular place on rent. Okay, there was a room, or you can say there was an apartment in a particular building from where a procession had to go. एक बिल्डिंग में उन्होंने एक अपार्टमेंट को रेंट में लिया जिसके सामने से एक जुलूस, एक यात्रा जाने वाली थी. वो यात्रा किसकी थी? एक राजा के राज्याभिषेक की. द किंग ऑफ द इंग्लैंड वाज टू गो फ्रॉम देयर फॉर हिज कोरोनेशन procession. So that was to go from there. Just before that procession, the king fell ill. As soon as the king fell ill, the procession was cancelled. When the procession was cancelled, so Krell, who was the owner of that particular apartment, said, see, Mr. Henry, you have just given me half of the payment. You have to give me the complete payment. Henry said, see, sir, the procession had to take place and it has not taken place. How come you can force me to pay the balance amount when I have not seen the procession, which was the very basis of the contract, and I had informed you that, see, I want to see the procession of the king, so I am taking this apartment. You only suggested, see, if you take this apartment, this place, this particular this one from this floor, this will give you the best view, the best जो नजारा होता वो सबसे बेस्ट होता. बट वो तो हुआ ही नहीं, बिकॉज प्रोसेशन एट द एंड हुआ ही नहीं. जब प्रोसेशन ही नहीं हुआ तो किस बात के पैसे मैं आपको दूं और कौन सा बैलेंस? The court also held the same thing. The court said, see, when the procession itself was not carried out and both the parties were well aware that the particular apartment was taken on rent only for the to watch this coronation procession, तो ये जब circumstances ही change हो गए, जब king ही बीमार हो गया, तो this change of circumstances will not make Mr. Henry liable to pay the rest of the balance. Right? So we have spoken already about two things: destruction of the subject matter and the change of circumstances. Third, which talks about death or incapacity of the party. Now, the case of Robinson versus Davidson, इसमें ये हुआ था कि हस्बैंड वाइफ थे और उसमें उनकी वाइफ बहुत अच्छा पियानो बजाती थी और इन्होंने कॉन्ट्रैक्ट किया था एक होटल के साथ कि सी वी आर गोइंग टू प्ले पियानोस, द वाइफ इज गोइंग टू प्ले द पियानो फॉर अ वीक्स टाइम. जस्ट बिफोर she had to perform this contract, she fell ill. बहुत बीमार हो गई, इतनी बीमार हो गई कि भाई उठ ही नहीं पाई, जा ही नहीं पाई, प्ले ही नहीं कर पाई। तब जो होटल मैनेजमेंट थी उन्होंने केस कर दिया कि भाई आप आए, आप नहीं आ पाए, दैट इज नन ऑफ आवर बिजनेस, बट यू नो यू हैव टू कॉम्पनसेट फॉर द लॉस बिकॉज वी हैड अरेंज्ड फॉर ऑल द अरेंजमेंट्स ऑफ योर कॉन्सर्ट एंड एवरीथिंग। आप तो परफॉर्म ही नहीं किए, आपका पियानो तो बजा ही नहीं, हमारे पैसे आए ही नहीं, हमें ऊपर से लॉस हो गया। सो व्हेन दिस पर्टिकुलर इंसिडेंट हैड हैपेंड, द कोर्ट हेल्ड, see, you cannot make somebody liable for some event in such nature. यहाँ पर वो जानबूझ के बीमार नहीं पड़ी थी, वो एक्टिंग नहीं कर रही थी, she was really ill and she could not perform that contract. That is why the contract actually got frustrated. Another example if we want, Robinson versus Davidson के अलावा एक और केस भी है जिसमें ये बात होती है कि भाई ए ने प्रॉमिस किया था बी को कि मैं आपकी पिक्चर पेंट करूंगा। पिक्चर पेंट करने के पहले ही व्हाट हैड हैपेंड, ए डाइड। अब बी की तो पिक्चर पेंट ही नहीं हो पाई, उनका तो पोर्ट्रेट माने पिक्चर जो बना ही नहीं। उन कंडीशंस में व्हाट कुड हैव हैपेंड, now you cannot hold A's legal heirs liable, क्योंकि वो तो कोई और पेंट करके नहीं दे सकता ना, A was painter, A had to do that, A नहीं कर पाया। So court in cases में ये कहती है, see, doctrine of frustration is applied in these type of areas, and why the ground is death or incapacity of the party. The party has died or they have become so incapacitated that they cannot perform further and they rendered the contract as frustrated. Fourth, where the government or administrative or legislative intervention is there. Now, यहाँ पे भूतलिंगा का केस है, भूतलिंगा एजेंसीज वर्सेस VTC Puriyaswamy Nadar. In this case, what had happened? This case is especially for all those baba who are a coffee lover. Okay, what had happened? The Bhutalinga agencies and VTC Puriyaswamy Nadar के बीच में ये था, from Germany they used to import a specific quality of chicory which is mixed in coffee, and that's how coffee is prepared. So this particular coffee was enlisted here with a lot of specifications that it will be of such and such nature, this quality, इतना amount, इतनी पूरी specification के साथ contract में already बताया गया था। और उसके बीच में क्या हुआ कि जर्मनी एंड इंडिया के बीच में तब वर्ल्ड वॉर 2 आया। वर्ल्ड वॉर 2 जब आया, देन बोथ ऑफ द कंपनी सेड, सॉरी, जर्मन कंपनी और इंडियन कंपनी के बीच में ट्रेड नहीं हो पाया। इंडिया ने बैन कर दिया कोई भी आउटसाइड कंट्री की किसी भी प्रोडक्ट को इंडिया में इंपोर्ट करने से। वंस द इंपोर्टेशन ऑफ द चिकरी वाज स्टॉप्ड, it was held that, oh my god, now this particular thing cannot be performed, right? उस समय भूतलिंगा एजेंसीज जो थी उन्होंने ये बोला कि भाई हम परफॉर्म नहीं कर सकते क्योंकि हमारे पास चिकरी आया ही नहीं और हम कॉफी बना ही नहीं पाए, तो हम कैसे उसको आपको सेल कर पाते। तब उन्होंने ये कहा कि भाई, देन कोर्ट हेल्ड कि यू कैन नॉट गिव सच, सॉरी, उस समय कोर्ट ने ये कहा कि when you are asking for chicory, you have already specified it in your contract in a very detailed manner, which kind of a chicory, what quantity, everything was already been enlisted. And when India banned it, then the chicory couldn't come to India. In certain circumstances, you cannot have the contract in enforcement. So this particular act was frustrated and doctrine of frustration was invoked here. So the performance of the contract यहाँ हो नहीं पाया, किस वजह से? Because government intervention था यहाँ, legislative intervention for some time, यहाँ पर सारे जितने भी contracts pending थे उन सबको standby में डाल दिया गया था due to the war. The fifth one was the intervention of war का ही जो मैं केस आपको बता रही थी। more or less इसके केसेस एक ही जैसे हैं। साइगा गोलू के अलावा I would like if you go with another case here. Okay, यहाँ AF Ferguson and Company versus Lalit Mohan Ghosh का एक केस है, which is a very interesting case. यहाँ पे इंश्योरेंस कंपनी थी जर्मनी की जो इंडिया के कुछ पर्टिकुलर एक कॉर्पोरेट को अपनी इंश्योरेंस पॉलिसी को सेल किया करती थी। यहाँ पे वो पॉलिसीज जो थी वो सेल आउट नहीं हो पाई क्योंकि हम दोनों कंट्रीज के बीच में सेम वॉर छिड़ गया एंड देयर वाज अ वॉर बिटवीन बोथ ऑफ द कंट्रीज। वर्ल्ड वॉर 2 की बात है ये भी, और इस वजह से द कॉन्ट्रैक्ट कुडंट बी rendered. So it was held with the company cannot insure, जो जिनको भी इंश्योर्ड किया गया है, the company cannot extend the insurance amount to the people who are working in that company because the war has come into place, right? But it was held that this whatever sum was assured, आपको किसी ना किसी मीन्स से तो भैया इसको वापस करना है, आप ये नहीं बोल सकते कि war was an action, that is why it couldn't be done. Why? Because the act of this could have been delayed but could not be terminated. With all the grounds moving further, there are 3 tests which are enlisted in section 56. I hope you are clear with the grounds of frustration, which talks about 5 things. सब्जेक्ट मैटर की डिस्ट्रक्शन की बात करता है, चेंज ऑफ सर्कमस्टांसेस की बात करता है, डेथ और इनकैपेसिटी की बात करता है, गवर्नमेंट इन्वेंशंस की बात करता है, इंटरवेंशंस की बात करता है, जहां पे गवर्नमेंट ने कोई और पॉलिसी बना दी है, कोई और रूल बना दिया है, तो इन सारे स्टेजेस में भी कॉन्ट्रैक्ट नहीं किया जा सकता है। एंड द लास्ट दैट देयर इज अ इंटरवेंशन ऑफ वॉर, right? Now moving further is test of frustration under section 56. In the case of Industrial Finance Corporation of India versus the Cananor Spinning and Weaving Mills Limited, 3 of the very, very important conditions were laid down. And what those conditions said? They said that there must be a subsisting contract. Number 1, कि contract ऑलरेडी सबसिस्टिंग होना चाहिए, रहना चाहिए, होना चाहिए, राइट? दोनों के बीच में कॉन्ट्रैक्ट ऑलरेडी एंटर्ड हो चुके होने चाहिए। आप सेकेंड, सम पार्ट ऑफ द कॉन्ट्रैक्ट इज स्टिल टू बी परफॉर्म्ड, मे बी हाफ ऑफ द ट्रांजैक्शन इज ओवर बट रेस्ट ऑफ द कॉन्ट्रैक्ट इज स्टिल पेंडिंग टू बी परफॉर्म्ड, सो देयर शुड बी पेंडेंसी इन कंटेक्स्ट ऑफ द एक्ट। Third was the performance has become impossible after the contract is entered into. Once the contract has been entered into, the very performance of that contract has now become impossible. How the impossibility might have come? The either of one of the grounds which we already discussed, subject matter खत्म हो सकता है, या किसी की डेथ या इनकैपेसिटेट हो सकता है, वो पागल हो सकता है वो, or there could be any change of circumstances. So such type of things can make the performance of the contract very much impossible or unlawful in nature. So this was the test which was laid down in Industrial Finance Corporation of India versus the Cananor Spinning Wheel. Now, whenever we read section 56, एक अपने आप ही एक सेक्शन आता है जिसे हम बिल्कुल नहीं छोड़ सकते, that is section 32. Section 32 talks about the contingent contracts. Now, what are the contingent contracts? Contingent contracts are something which depend on any event or there is a condition attached to that particular contract. For example, A says that I will marry, A says I will marry B if C gives consideration of 2,000 rupees to me. Suppose this type of an example is there. So जैसे ही ये हो जाएगा, then A will marry B, right? So this type of transaction is the contingent contract, which depends majorly on any of the condition or an event which has been pre-decided. Section 56 on the contrast, what does it say? It says that यहाँ पे भाई एक एक्ट हुआ, एक इवेंट हुआ, बट इवेंचुअली इस एक्ट और इवेंट की वजह से एक परफॉर्मेंस ऑफ द कॉन्ट्रैक्ट हिंडर हो गया, फ्रस्ट्रेट हो गया, एंड व्हाट हैज कम अप in section 32. Let me read out to you. Technically, under both the section 32 and 56, the contract can be discharged on impossibility of certain events in the future. दोनों ही discharge करते हैं from the performance of the contract. How they do? 32 तुरंत discharge हो जाएगा जैसी ही condition complete हो जाएगी, जो भी condition थी अगर जैसी ही वो honor हुई discharge हो गया। In 56, भाई जैसे ही 56 में क्या हुआ, जैसे ही कोई इवेंट या सर्कमस्टांसेस हुआ तब आपका रोल इनटू बीइंग आया, तब आपकी जो इम्पॉसिबिलिटी थी दैट हैज कम इनटू एक्शन. सो सेक्शन 32 and 56 talks about two distinct things, though one talks about a conditional one and another talks about an event which has. Section 32 deals with a contingent contract which is dependent on the fulfillment of condition for its survival. That's what we discussed कि एक condition है, इसकी वजह से वो आया है, right? And a contingent contract will dissolve under its own force if the condition is not satisfied, whereas section 56 is attracted when the contract becomes impossible to perform because of an outside force. If some event, वॉर हो गया, कोई गवर्नमेंट ने पॉलिसी चेंज कर दिया, कोई डेथ हो गई, यहाँ पे उनका रोल नहीं था, contract was very much valid, some subsequently event has occurred which has made the contract now very much impossible in nature. So contingent contract depends on a condition and section 56 comes into play when such kind of unforeseeable or unforeseeable events occur into being. All right. So moving further, the incentive, there is an incentive which makes the distinction between section 32 and 56. Now, what is that distinction? The distinction is of the compensation. सेक्शन 32 कोई भी कंपनसेशन की बात नहीं करता है, वो ये नहीं बोलता है कि ये एक्ट नहीं हुआ, अब रेंडर नहीं हुआ, अब खत्म हो गया, ये कंडीशन हो गई तो I will compensate. No, section 32 doesn't explicitly say about anything about compensation, but section 56 surely talks about compensation. It says under the para 3, it says that if a party defaults unknowingly or knowingly in certain areas, then he is liable to pay the compensation to the third party, to the loss incurring party. Now, the factors not amounting to the frustration of the contract. There are certain areas where we feel the contract has been frustrated, but those particular grounds or areas doesn't come under the doctrine of frustration. Now, what all these areas are? Commercial hardship or difficulty. What do you mean by commercial hardship or difficulty? भाई, A ने B को सामान भेजना था, अचानक से there was a price rise, अचानक से शिपमेंट के कॉस्ट में राइज हो गया और उसने बोला भाई नाउ द डॉक्ट्रिन ऑफ फ्रस्ट्रेशन इज हैज बीन इन्वोक्ड हियर, क्योंकि प्राइस राइज इतना हो गया, महंगाई इतनी बढ़ गई है कि अब मैं इसको इस कंसिडरेशन में नहीं बेच सकता. So you cannot have such kind of explanations, such kinds of relief, because कोई mere price rise or mere change in any kind of inflation or such kind of areas, you cannot plead for commercial. This is commercial hardship. यहाँ पे कमर्शियल डिफिकल्टी आ गई है, रेट्स में चेंज आ गई है, बट आपके कॉन्ट्रैक्ट के नेचर में चेंज नहीं हुआ है. ए हैज टू स्टिल सेंड द शिपमेंट टू बी, वेदर इट इज फॉर मोर ऑफ द कॉस्ट और लेस ऑफ अ कॉस्ट, दैट इज नॉट मटेरियल हियर. ठीक है, तो इस टाइप के जो कॉन्ट्रैक्ट्स होते हैं जहां कमर्शियल हार्डशिप क्या बोलते हैं की वजह से माने यहाँ पे हो नहीं सकता क्योंकि प्राइस राइज हो गया, इन सारी चीजों की वजह से you cannot have to say that your doctrine of frustration has been invoked. The second area is no frustration of executed contracts. A और B के साथ भैया कॉन्ट्रैक्ट था, अब यहाँ पे कॉन्ट्रैक्ट का अगर मैं एग्जांपल देना चाहूँ तो A और इंडिया एंड पाकिस्तान के बीच की बात करते हैं. भाई पार्टीशन के ड्यूरिंग A जो था, A और B दोनों पाकिस्तान में रहते थे. A ने लीज में लिया था B से एक लैंड. क्या लिया था? A ने B से लिया था लीज में एक लैंड. अब यहाँ पे वो अपनी खेतीबाड़ी करने के लिए कॉन्ट्रैक्ट में दे दिया. कॉन्ट्रैक्ट में देने के बाद अचानक से पार्टीशन हुआ 1947 में. जब पार्टीशन हुआ तो ए जो है ही माइग्रेटेड टू इंडिया. बट इसमें ये भी एक केस लॉ है, कोर्ट ने ये बोला था कि भाई यहाँ पे कॉन्ट्रैक्ट खत्म नहीं हुआ है. और कॉन्ट्रैक्ट क्यों नहीं खत्म हुआ है? बिकॉज आपको ये आपने कहीं कॉन्ट्रैक्ट में नहीं कहा था कि आप सुपरविजन जो है वो पर्सनली जाके करेंगे, वहां पर्सनली जाके खड़े होके करेंगे. ये कॉन्ट्रैक्ट में कहीं भी नहीं मेंशन था. वो तो वैसे भी कॉन्ट्रैक्चुअल ऑब्लिगेशन में था, आपने कॉन्ट्रैक्टर को दिया था. कि भाई फार्मिंग करो, ये करो, मैं बस प्रोसीड्स बेचने आऊंगा और मैं उसका रिटर्न लेके जाऊंगा. सो व्हाट डू यू मीन हियर दैट देयर इज नो फ्रस्ट्रेशन ऑफ एग्जीक्यूटेड कॉन्ट्रैक्ट्स का मतलब क्या है कि जो ऑलरेडी एक कॉन्ट्रैक्ट एग्जीक्यूट हो चुका है उसके लिए आप फ्रस्ट्रेशन को प्लीट नहीं कर सकते हैं यहाँ पे. The third point is inherent or foreseeable risk. There is some risk which you can foresee. आपको पता है कि आप ये कॉन्ट्रैक्ट कर रहे हैं बी के साथ और ये आइटम जिसके ऊपर आप कॉन्ट्रैक्ट कर रहे हैं ये आउट ऑफ मार्केट हो सकता है, ये जा सकता है. ऐसे सारी रीजनेबल और जितने भी फोर्सेबल रिस्क आप देख सकते हैं और उसके बावजूद इफ यू गो एंड डू योर कॉन्ट्रैक्ट देन यू वोंट बी रिलीव्ड फ्रॉम द लायबिलिटी टुवर्ड्स इट. आप ये नहीं बोल सकते कि भाई डॉक्ट्रिन ऑफ फ्रस्ट्रेशन आ गया क्योंकि ये तो हमें पता ही नहीं था. ये तो आप बोल ही नहीं सकते बिकॉज यू ऑलरेडी यू कुड हैव फोरसीन दिस पर्टिकुलर प्रॉब्लम इन इट. फोर्थ, दिस सेल्फ इंड्यूस्ड फ्रस्ट्रेशन, जहां पे आपने खुद से ही या एक सेल्फ इंड्यूस्ड फ्रस्ट्रेशन के अंदर ही इनहेरेंट फोर्सेबल रिस्क भी आता है, बट आई हैव मेड इट डिफरेंट बिकॉज नॉन परफॉर्मेंस ऑफ द कॉन्ट्रैक्ट भी सेल्फ इंड्यूस्ड फ्रस्ट्रेशन के अंदर आता है. आपको पता था, आप जानते थे, लेकिन आपने परफॉर्म नहीं किया एंड लेटर ऑन आप ये रिलीफ ले रहे हैं कि भाई this was a self-induced frustration. So as in ये मैं perform नहीं कर पाया because मुझे difficulty आ गई, मैं नहीं कर पाया. इस तरीके के अगर आप plea लेते हैं तो this will not be honored. You have committed a mistake. You have done by yourself and ये breach of contract के अंदर चले जाएगा, ना कि doctrine of frustration के अंदर आएगा. Because for doctrine of frustration there should be an like unforeseeable event has to happen and the performance of a contract should render or land up into the impossibility criteria and category. Last one is no frustration by mere delay in the performance. So no frustration by mere delay in the performance of the contract. अगर merely कोई contract delay हो रहा है, एक shipment को 40 दिन में आना था आपके लिए, ठीक है, वो 45 दिन में हो गया, तो आप ये नहीं बोल सकते नहीं नहीं अब मैं ये कॉन्ट्रैक्ट में शिपमेंट का सामान नहीं लूंगा क्योंकि द कॉन्ट्रैक्ट हैज बीन फ्रस्ट्रेटेड. यू कैन नॉट टेक दिस प्ली. व्हाई? बिकॉज देयर हैज बीन जस्ट अ डिले इन द कॉन्ट्रैक्ट. परफॉर्मेंस तो हुआ है, डिले हो गया है कुछ कारणों की वजह से, तो आप ये नहीं बोल सकते कि दिस कॉन्ट्रैक्ट हैज बीन फ्रस्ट्रेटेड. मूविंग नेक्स्ट, as I said, we will have a questionnaire round here. So I am giving back to Chandrika Bose. I hope you understood what I tried to bring out. Though we will have the brief explanations and the brief area of the doctrine of frustration because it's a very, very big concept and cannot be brought in a small time. So with the paucity of time and everything, I'm giving it to Chandrika to take the other briefings which she wants to do. And you take a 2 minutes break. Thereafter, we'll come for the questionnaire.
Thank you, ma'am. Guys, as I told you earlier, that we are coming with a 90-day program for CLAT PG. And as we are starting with our free demo classes from 1st of March for 5 days. If you guys want to get benefited with the course, you can just register yourself. The link has been shared in the comment section. And in case you have any doubts or queries, you can just contact us at rostonlegal.com. Over to you, ma'am.
Thank you. So let us quickly go for the questionnaire which we had. So the first question which is there, I would like all the students who know the answer to it or can guess from whatever I have taught or whatever we discussed just now to please write it in the comment section. In India, the doctrine of impossibility of performance rendering contracts void is based on the theory of implied terms, on the theory of just and reasonable solution, on the supervening impossibility or illegality as laid down in section 56 of the Indian Contract Act, or on the principle of unjust enrichment. What do you think? We have some 4 questions. I'm just giving you these questions so that you get an idea that what kind of questions are actually coming in CLAT PG examinations and all, and in which way the sections, the case laws which we discussed, how the areas, the minor areas which we discussed, no, para 1, para 2, para 3, how these help. So, shall I go on to the question number 2? I believe we should, or we will discuss it in the end. What do you say? Let me give the answer right away. All right. Okay. So the right answer of this is, in India, the doctrine of impossibility of performance rendering contracts void is based on the supervening impossibility or illegality as laid down in section 56 of the Contract Act. All right, let's go on quickly to the second question. That is, the first case on the doctrine of frustration as decided by the Supreme Court of India is Basanti Bastralia versus River Stream Navigation Company Limited, Raja Dhruva Dev versus Raja Harmohinder Singh, Sushila Devi versus Hari Singh, or Satyavrata Ghosh versus Mungni Ram. I have taught you. All right. Have you commented? I hope you might have. The option D, Satyavrata Ghosh versus Mungni Ram, which deals with the land thing, that earnest money was already given, military, German, during the Second World War, the German association with India and everything में, the war time में जो ले लिया था land, उस particular land, the developing area and all that, कुछ याद आ रहा है? This was the case, Satyavrata Ghosh versus Mungni Ram. Let's go on to the third one. Which doctrine was in vogue or praxis? Vogue or praxis का मतलब होता है usage or in custom or in practice before the doctrine of frustration. Doctrine of frustration के पहले कौन सा ऐसा law था जो in usage, in practice था? Doctrine of unjust enrichment, doctrine of implied term, doctrine of non-performance, or none of the above? The right answer is doctrine of implied term. जो भी implied term contract में लिखा जाता था, it used to be followed as it is. There was no frustration concept that time. There was no relief of this frustration was given at that point of time. The last but not the least, here this question is based on illustration. I hope you answer it correctly. A contract to marry B, being already married to C and being forbidden by the law to which he is subject to practice polygamy. Now, what is the right answer? Could be A, must compensate B for the non-performance of his promise. A, does not have to make any compensation to B because law does not permit him to marry another woman. If B asks for compensation, then only A can comply with it. None of the above, being the last option. So what is the right answer to it? The right answer is A, must compensate B for the non-performance of the promise. A ने promise कर दिया B को मैं तुमसे शादी करूंगा, while he was already married to C, और नहीं हो सकता because this is forbidden by law. This is very illegal in nature. So अगर ये promise उसने किया है, then he has to make her good by suffering all the losses of her. So A must compensate B for the non-performance of the promise. So this was the small questionnaire round, I believe, and I think now you might be clear with the concept of doctrine of frustration. So wishing you all the best for all of your examinations. Thank you, Chandrika.
Thank you, ma'am, for this enlightening session. Hope everyone has a better understanding of doctrine of frustration now. I would also like to thank everyone who attended the webinar. And don't forget to like and subscribe to our channel. Thank you so much for joining. Have a great day ahead.
Thank you. Thank you all.